You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The Cybersecurity Information Sharing Act of 2015, often shortened to CISA, was enacted to encourage greater collaboration between private companies and the federal government in combating cyber threats. At its core, the law sought to address a persistent problem. Organizations were often hesitant to share cyber threat intelligence because of liability concerns, competitive sensitivities, and uncertainty about privacy implications. CISA provided a framework for voluntary, structured, and protected exchange of information, aiming to create a near real-time ecosystem where data about malicious activity could be shared broadly and acted upon quickly. For learners, CISA represents a turning point in federal cybersecurity policy, emphasizing that effective defense against advanced threats requires collective action. It illustrates how law can be used to reduce friction, align incentives, and build trust in a domain where speed, coordination, and clarity often make the difference between containment and catastrophic compromise. One of the Act's central terms is Cyber Threat Indicator. These indicators are defined broadly to include not just specific malware signatures but also tactics, techniques, and procedures known as TTPs that adversaries use in campaigns. Examples might range from IP addresses and domain names associated with command and control servers to patterns of suspicious login attempts that suggest credential stuffing. For learners, this definition highlights the importance of flexibility. A cyber threat indicator is not just a static technical artifact, but a piece of intelligence that, when contextualized, can help defenders anticipate and disrupt attacks. By codifying a broad definition, CISA ensured that information sharing would remain relevant even as adversary methods evolved, capturing both technical markers and strategic behaviors within its framework. Equally important is the definition of defensive measure. Under CISA, defensive measures refer to non-destructive actions that owners or operators of systems may take to protect against or mitigate threats. This includes activities such as deploying intrusion detection systems, monitoring network traffic, or applying automated blocking of known malicious IP addresses. However, it explicitly excludes offensive operations that would damage or disrupt systems not owned by the defender. For learners, this distinction reflects the ethical and legal boundary between defense and retaliation in cyberspace. While organizations may act aggressively to secure their own environments, they cannot extend those actions into counterattacks against third parties. This boundary keeps sharing focused on protective measures, avoiding escalation or collateral harm, while still enabling robust defense. The Department of Homeland Security, through what is now the Cybersecurity and Infrastructure Security Agency, was designated as the central hub for receiving, analyzing, and distributing shared indicators. DHS was tasked with creating automated pipelines that could receive threat data from private entities, apply filtering to protect privacy, and then distribute the refined information to other participants. For learners, this hub-and-spoke model demonstrates how centralization can provide both efficiency and trust. By making DHS the gateway, Congress avoided a fragmented system where companies might have to choose among competing agencies. It also underscored the role of government as both a partner and a steward, responsible for ensuring that shared data was handled consistently with privacy guidelines while being made useful to a wide range of defenders. A key innovation in CISA was its vision for near real-time automated sharing. The Act called for technical systems that would allow indicators to be transmitted, filtered, and redistributed with minimal human delay. In practice, this meant building automated interfaces, such as DHS's Automated Indicator Sharing Program, capable of delivering cyber threat intelligence at machine speed. For learners, this reflects a recognition of the time-sensitive nature of cyber defense. Threats evolve by the minute, and intelligence that arrives days or weeks late may be irrelevant. By prioritizing automation, CISA illustrated how law can push operational practices toward immediacy, aligning legal frameworks with the realities of digital threats, where response windows are measured in hours, not months. Liability protections were perhaps the most significant incentive created by CISA. Companies that monitored their systems, shared indicators with the federal hub, or received shared data were shielded from civil liability, provided their actions were conducted in good faith and within statutory guidelines. This protection applied broadly, covering concerns about privacy lawsuits, contractual disputes, or accusations of anti-competitive behavior. For learners, these provisions underscore how risk aversion often inhibits cooperation. By removing the fear of lawsuits, Congress attempted to unlock more robust participation. Liability shields became the backbone of the law's strategy. They reassured companies that sharing intelligence for the common good would not boomerang into financial or reputational harm. Related to liability was the establishment of an antitrust safe harbor. CISA made clear that competitors sharing cybersecurity indicators in order to improve collective defense would not be considered in violation of antitrust laws. This was crucial because many sectors, such as finance or telecommunications, rely on close collaboration between competing firms to track and defeat common adversaries. For learners, this provision illustrates how legal constraints designed for market competition can unintentionally inhibit security cooperation. By carving out a safe space, the Act recognized that collective cyber defense benefits everyone, including consumers, and should not be stifled by outdated interpretations of competitive law. Transparency protections were also built into the framework. Shared indicators were exempted from disclosure under the Freedom of Information Act, ensuring that sensitive details voluntarily submitted by companies would not later be released to the public or competitors through open records requests. For learners, this demonstrates how privacy and confidentiality protections can encourage participation. Without such assurances, companies might hesitate to share, fearing reputational damage or exposure of vulnerabilities. FOIA exemptions reassured organizations that sharing for defense would not inadvertently create public disclosures that adversaries could exploit. Privilege preservation was another safeguard. CISA specified that information shared under its authority would not waive attorney-client privilege or other legal protections. Furthermore, it limited the use of shared data in legal proceedings, ensuring that cybersecurity information could not be repurposed as evidence in unrelated litigation. For learners, this shows how law can address practical business concerns. Legal privilege is a cornerstone of corporate governance, and if sharing cybersecurity information jeopardized that, participation would collapse. By preserving privilege, the Act reinforced that the scope of sharing was narrow, protective, and aligned with collective defense rather than opportunistic litigation strategies. One of the most important privacy-focused requirements of the Act was the mandatory removal of personal information not directly necessary for cybersecurity purposes. Before indicators could be disseminated, agencies and private sharers were required to scrub fields that might identify individuals unless they were essential to understanding the threat. For learners, this principle of privacy filtering demonstrates how surveillance and privacy can coexist when properly managed. The law acknowledged that threat indicators often coexist with personal data, but required minimization to prevent collateral exposure. This step ensured that the community defense model advanced security goals without undermining civil liberties or unnecessarily intruding into individuals' personal lives. Privacy and civil liberties guidelines were further embedded in the statute, requiring DHS and other agencies to publish policies on how shared information would be handled, disseminated, and secured. These guidelines served as guardrails, ensuring that national security and cyber defense priorities did not eclipse privacy considerations. For learners, this reflects how legislation integrates accountability by design. Privacy is not an afterthought. It is a documented, audited, and transparent obligation tied directly to operational practices. Embedding civil liberties oversight helped mitigate fears that information sharing could become another form of unchecked surveillance under the banner of cybersecurity. CISA also imposed federal use limitations on shared indicators. Information could only be used for cybersecurity purposes or in response to serious threats such as imminent danger of death or significant physical harm. This restriction ensured that intelligence voluntarily shared for one purpose would not be diverted into unrelated investigations such as minor criminal cases or regulatory enforcement. For learners, this illustrates the principle of purpose limitation applied to national security contexts. It reinforces that trust depends on aligning the use of data with the expectations under which it was shared, and that violating that alignment risks undermining the entire framework of collaboration. Finally, the Act formally recognized and integrated Information Sharing and Analysis Organizations (ISAOs) and Information Sharing and Analysis Centers (ISACs) into the ecosystem. These sector-specific groups already facilitated sharing among industries like finance, healthcare, or energy, and CISA gave them a formal role in connecting to federal pipelines. For learners, this demonstrates how legislation can build on existing practices rather than starting from scratch. By aligning sector-driven communities with federal hubs, the Act created a more cohesive network. It acknowledged that defenders often trust peer-based organizations more than federal channels and leveraged those trust relationships to broaden participation while maintaining consistency with national frameworks. CISA authorized system monitoring by private sector owners to detect, analyze, and prevent cybersecurity threats. This provision codified the right of companies to monitor their own networks and to share relevant data without fear of violating wiretap statutes. For learners, this represents a crucial legal clarification. Prior to CISA, ambiguity about how existing privacy laws applied to monitoring created hesitation. By explicitly authorizing defensive monitoring, the Act empowered organizations to take proactive steps, ensuring that vigilance on private systems was both lawful and encouraged. This reflects the law's dual purpose: to clear away legal uncertainty and to establish a consistent baseline for protective action across diverse industries. Lastly, the Act defined the boundaries of defensive measures by prohibiting any actions that would harm the systems or data of others. Companies were authorized to deploy tools and practices that defended their own assets, but not to cross the line into retaliatory hacking or countermeasures. For learners, this prohibition reinforces the narrow focus of CISA. Its purpose is cooperative defense, not escalation. By drawing a bright line between defense and offense, the statute reduced risks of unintended damage, diplomatic incidents, or collateral harm. This restraint illustrates how legal frameworks aim to foster resilience without endorsing vigilante-style tactics that could destabilize cyberspace. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. The Cybersecurity Information Sharing Act did not stop at enabling the flow of indicators. It also prescribed detailed rules for how federal agencies handle, retain, and disseminate shared data. Agencies such as the Department of Homeland Security were required to maintain audit logs of what indicators were received, who accessed them, and when they were distributed. Retention schedules ensured that indicators were not stored indefinitely, reducing the risk of unnecessary exposure. For learners, these provisions highlight how accountability is embedded into technical systems. Auditability and retention limits are not mere administrative tasks, but fundamental privacy safeguards. They guarantee that information provided in the spirit of collective defense is not stockpiled for unrelated purposes. This framework reassures participants that their contributions will be managed responsibly, balancing the urgency of cyber defense with long-standing principles of minimization and purpose limitation. Transparency was another cornerstone, with Congress mandating periodic reporting on the performance of CISA's programs. Agencies were required to publish metrics on how many indicators were shared, how quickly they were processed, and how often privacy protections were applied. These reports served both oversight and public trust functions. For learners, This reflects a recognition that secrecy in cybersecurity can undermine legitimacy. By releasing aggregate statistics, the government created space for public evaluation of whether CISA was achieving its goals without exposing sensitive operational details. Transparency obligations demonstrate how democratic systems adapt to technical domains. Even in areas dominated by classified information, structures exist to provide visibility, accountability, and assurance that programs are not operating in the shadows unchecked. CISA also extended access to shared threat intelligence beyond the federal level, explicitly including state, local, tribal, and territorial governments. These entities often own critical infrastructure or provide essential services such as water, healthcare, and emergency response, yet lack the same cybersecurity resources as federal agencies. By creating pathways for them to connect to federal sharing channels, CISA aimed to level the playing field. For learners, this inclusion illustrates the layered nature of cybersecurity governance. National defense depends not only on federal systems but on every interconnected node. Extending access beyond Washington reinforced the idea that resilience is collective, and that privacy-protected sharing should benefit every tier of government, not just elite federal institutions. Recognizing that some indicators and defensive intelligence are classified, CISA facilitated pathways for companies to obtain clearances where appropriate. This provision acknowledged that the most sophisticated threats often come from nation-state adversaries, and private operators of critical infrastructure need visibility into classified insights to defend themselves effectively. For learners, classified sharing illustrates the tension between secrecy and empowerment. Expanding clearances widens the circle of those who know, potentially increasing risk of leakage, but it also empowers defenders to act against advanced campaigns. CISA attempted to balance this by creating controlled channels, ensuring that critical operators could receive the intelligence they need, while maintaining security discipline in the handling of classified materials. Sector-specific adoption patterns soon emerged under CISA. Industries like finance and telecommunications, already accustomed to working in collaborative frameworks, embraced indicator sharing more rapidly than sectors such as healthcare or education. These differences reflected maturity in governance, resourcing, and risk culture. For learners, this uneven adoption shows how law interacts with organizational readiness. Statutory incentives can create structures, but actual participation depends on trust, awareness, and investment. CISA thus became a catalyst for highlighting which industries were leading in cybersecurity cooperation and which required more outreach and support. Adoption patterns remind us that legal authority is only one piece of the puzzle. Culture and capability determine how effectively reforms are realized. Indicator quality quickly became a focal issue. Automated feeds can overwhelm participants with high volumes of indicators, many of which may generate false positives or lack sufficient context to be actionable. CISA anticipated this by embedding feedback loops, allowing organizations to evaluate the utility of shared data and refine contributions. For learners, this emphasizes that sharing is not just about volume but about relevance. Quality assurance processes transform raw technical details into usable intelligence, and feedback mechanisms ensure continuous improvement. In practice, this means that collective defense evolves, learning from mistakes and improving with each cycle of indicator exchange, demonstrating how privacy-aware governance must also be precision-driven to avoid unnecessary operational burdens. The Act explicitly tied indicator sharing to enterprise risk management and incident response processes. Organizations were encouraged to integrate shared intelligence into their security operations centers, detection tools, and response playbooks. For learners, this integration demonstrates how legal frameworks translate into operational resilience. Indicators lose value if they remain in isolated repositories. They become transformative when aligned with enterprise processes that govern detection, mitigation, and recovery. CISA's provisions highlight the importance of embedding information sharing into day-to-day governance, ensuring that privacy-protected collaboration translates into tangible improvements in security posture and not just compliance checkboxes. Managed security service providers and vendors also became central players under CISA. Many organizations, especially smaller ones, relied on third parties to scale their defenses. The Act recognized this dynamic, ensuring that liability protections extended through vendor chains and that contractual relationships could incorporate sharing obligations. For learners, this underscores the interconnectedness of modern cybersecurity. Trust is distributed across ecosystems, and liability shields help ensure that even indirect participants can contribute without fear of legal consequences. Vendors amplify the benefits of CISA by extending the reach of shared intelligence to organizations that might not otherwise have the technical or staffing capacity to participate directly. Data security safeguards were mandated for repositories, interfaces, and exchange platforms handling indicators. Encryption, access controls, and audit logs were required to prevent unauthorized access or leakage. For learners, this provision illustrates how privacy and security converge in governance. Information sharing cannot strengthen defense if the very platforms used to exchange intelligence become vulnerabilities. By embedding security requirements, CISA reinforced the principle that privacy protection must extend to infrastructure, ensuring that the tools enabling collaboration are as resilient as the systems they are designed to protect. This reflects a broader truth. Governance of cybersecurity sharing is not just about rules for participants, but also about fortifying the platforms that underpin trust. Contractual clauses were another practical dimension addressed by CISA. Organizations were encouraged to include explicit provisions in contracts with partners and customers that authorize sharing of indicators within legal boundaries. For learners, this highlights how privacy and liability are managed not only through statutes but also through business agreements. Contracts operationalize legal protections, ensuring that companies can meet their CISA obligations without breaching other commitments. By embedding sharing rights into contractual frameworks, organizations aligned legal obligations with commercial trust, reinforcing the ecosystem of collective defense while preserving clarity and accountability in customer relationships. International considerations were inevitable, given the global nature of cyber threats. CISA recognized the challenges of cross-border operations, where indicators relevant to U.S. defense might also involve data subject to foreign privacy regimes, such as the EU's General Data Protection Regulation. The Act emphasized comity and coordination, encouraging careful handling of international data flows. For learners, this dimension illustrates the globalized character of privacy governance. Sharing cannot be confined within national borders. Adversaries operate across jurisdictions, and defenders must navigate overlapping legal frameworks. CISA highlighted the need for international trust frameworks that balance national security imperatives with respect for foreign privacy laws. Metrics were established to evaluate the timeliness, utility, and actionability of received indicators. These performance measures gave Congress, agencies, and private participants a way to judge whether CISA was working as intended. For learners, metrics underscore the importance of measuring outcomes, not just inputs. Simply counting the number of indicators shared is insufficient. What matters is whether they improve detection, shorten response times, and prevent harm. Metrics provide an evidence base for governance, ensuring that reforms are continually assessed and refined in line with evolving threats and privacy expectations. CISA also emphasized the value of post-incident sharing. After significant breaches or attacks, organizations were encouraged to share indicators and lessons learned to harden defenses across sectors. For learners, this provision reflects the principle of collective learning. Privacy-filtered information shared after an incident helps prevent repetition of the same vulnerabilities and strengthens resilience at a systemic level. By embedding post-incident sharing, the Act moved beyond a reactive model to one that treats each breach as a source of intelligence for the community, turning setbacks into opportunities for collective progress. Finally, the Act called for a governance playbook that aligned legal protections with technical implementation. This playbook included guidelines for filtering personal information, handling classified data, engaging vendors, and reporting metrics. For learners, the playbook demonstrates how statutes become operational realities. Law provides the framework, but governance structures translate it into repeatable processes. The emphasis on governance shows that privacy and collaboration are not achieved by text alone. They require continuous translation into policies, training, and technology that together create a sustainable ecosystem for information sharing. In conclusion, CISA of 2015 represented a landmark attempt to build a legal and operational infrastructure for cybersecurity collaboration. Its reforms emphasized privacy-filtered sharing, liability protections, transparency, and technical safeguards, creating an environment where companies could contribute to collective defense without undue risk. For learners, the Act illustrates how law, privacy, and technology intersect to foster community resilience. The lesson is clear. Cybersecurity in a networked age is not a solo endeavor, but a cooperative enterprise, sustained by trust, reinforced by governance, and made effective through timely and disciplined sharing of actionable intelligence. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.